Nature of contract, meaning. The nature of a contract explains its basic legal characteristics. A contract is not a mere promise, it is a legally binding and enforceable agreement. Governed by the Indian Contract Act, 1872. Small blue diamond essential features showing the nature of a contract. QRN 1 based on agreement. Every contract starts with an agreement. Agreement equals offer plus acceptance. It involves mutual promises and consensus ad idem, meeting of minds. Only legally enforceable agreements become contracts. Example. A offers to sell his bicycle to B for 5,000 Indian rupees and B accepts agreement becomes contract if legal requirements are fulfilled. Case law. Pushpin Balfour vs. Balfour, 1919. Social domestic agreements without legal intention are not contracts. QRN 2 legally enforceable. Legal enforceability is the most important feature. Only agreements enforceable by courts of law are contracts. Social, moral, or domestic agreements are generally not enforceable. Example. Promise to give a gift not enforceable. Agreement to sell a car enforceable. Case law. Pushpin Balfour vs. Balfour. Domestic arrangements lack legal enforceability. QRN 3 creates legal rights and obligations. A contract creates a legal relationship. One party gets a right, the other has a duty. Breach gives rise to legal action. Example. A agrees to sell house right to price. B agrees to pay price right to property. Case law. Pushpin Carlile vs. Carbolic Smoke Ball Co. 1893. Contract created enforceable rights and obligations. QRN 4 voluntary in nature, free consent. Contract must be entered into by free will. Consent must not be caused by coercion, undue influence, fraud, misrepresentation, mistake. If consent is not free, contract is voidable. Example, agreement signed under threat not voluntary. Case law. Pushpin Ranganayakama vs. K. Prakosh, 2008. Consent obtained by undue influence is not free. QRN 5 lawful object and lawful consideration. Object and consideration must be lawful. Must not be illegal, immoral, fraudulent, against public policy, forbidden by law. Unlawful object consideration void agreement. Example, agreement to commit a crime void. Case law. Pushpin Gerilal Parokh vs. Mahadiadas Mu, 1959. Explained unlawful object and public policy. QRN 6 certainty and possibility of performance. A. Certainty. Terms must be clear and definite. Vague agreements are void. Example, agreement to sell a car without details void. Case law. Pushpin Scammell vs. Austin, 1941. Uncertain agreements are unenforceable. B. Possibility of performance. Contract must be capable of performance. Agreement to do an impossible act void. Example, agreement to bring a dead person back to life. Case law. Pushpin Satyabrata Ghose vs. Mugneeram Banga and Co. 1954. Explained impossibility under Section 56. QRN 7 results in remedies on breach. Breach occurs when a party fails to perform. Law provides remedies, such as damages, specific performance, injunction, rescission, quantum meruit. Example, failure to deliver goods damages claim. Case law. Pushpin Hadley vs. Baxendale, 1854. Laid down principles for damages. Conclusion. A contract is a legally binding, voluntary, and enforceable agreement. It is based on mutual consent, lawful object, and certain and possible performance. It creates legal rights and obligations and provides remedies on breach. Thus, the law of contract ensures certainty, fairness, and justice in transactions.